Trespass or tolerance, when neighborhood shortcuts cross legal lines. 1. The problem next door. A couple wrote in with a simple but unsettling question. Their neighbor's children walk across a grassy lot they own to reach the school bus stop. It's private property, never fenced, never posted, but used daily without permission. The couple wonders, if someone gets hurt, could they be liable? And would giving permission make that liability better or worse? So what does that actually mean? It means they're balancing politeness with legal exposure, a line as thin as the grass the kids are trampling. Footnote. Property owners face competing pressures between legal protection of land rights and maintaining community goodwill. 2. The right to exclude. At law, ownership carries one ultimate power, the right to exclude. You can say stay off my property, and legally, that's enough. But practically? It's hard to be the neighbor who blocks kids from walking to school. And while you can enforce your rights, the cost may be social, not just legal. Still, the right exists, and ignoring it too long can complicate future enforcement. Footnote. Ownership includes the right of exclusion, but enforcement often involves community and reputational trade-offs. 3. The Michigan Rulebook. In Michigan, and in many other states with similar laws, trespassing has both criminal and civil sides. The criminal side lives in MCL 750.552, which forbids entering or remaining on land after being told not to. If the property is fenced or posted with no trespassing signs, even prior notice isn't required. Unfenced and unposted land, however, gives strangers the benefit of the doubt, until they're told otherwise. In short, post it or say it out loud. Footnote. Under Michigan law, explicit notice, verbal or posted, is generally required before casual entry becomes criminal trespass. 4. Civil trespass and the price tag. Civil law offers a private remedy under MCL 324.73102. If someone enters fenced or conspicuously posted land without permission, the owner can sue for at least $750 per incident, plus attorney fees. It's the legal system's version of a keep off the grass sign with teeth. Few people use it over school children, but the law allows it. Footnote. Civil statutes enable property owners to recover monetary damages and legal costs from unauthorized entrance. 5. The liability fear. Here's the real concern: if a child walking across the property breaks an ankle, can the owner be sued? Yes. In America, anyone can sue anyone. But whether they win depends on duty of care. Trespassers get minimal protection, owners must not intentionally harm them. But if the kids are licensees, people using the land with implied permission, the duty rises. Ironically, granting permission may slightly increase liability because it implies consent and awareness. Footnote. Property owners owe a higher duty of care to permitted entrance than to trespassers, affecting potential liability. 6. Posting, fencing, or peacekeeping. So, what can they do? Options range from quiet to confrontational. 1. Post no trespassing signs, legally effective, socially awkward. 2. Fence or mark the boundary. 3. Talk to the parents, politely, but risk neighborhood drama. 4. Do nothing, accepting minor risk for major peace. Every path has trade-offs. In law, silence can seem like consent; in neighborhoods, enforcement can seem like hostility. Footnote. Deterring trespass can be achieved through signage or boundaries, though each method carries social consequences. 7. The bigger picture. This story isn't just about one yard. It's about the uneasy space between law and community. The law says property is sacred. Real life says fences make enemies faster than friends. The safest move, legally, is to post signs. The wisest move, socially, is to handle it with grace. Either way, the kids will reach the bus stop, the only question is whose yard they'll cross to do it. Footnote: the tension between property enforcement and neighborly coexistence highlights the gap between legal rights and practical living.